everybody. How are you doing on this fine Monday? We are back again for a new week. I am trying something new where I am going to do a little Diddy docket update as a podcast. I do have a whole separate little podcast situation going on where I'm reading like just stuff from the Diddy docket and it's numbered. So I just started doing that at like number like 76 or something, but we're up to today. It's 85 and 86. Okay, now the documents we're going to be reading are the two letters. It's going to be a reaction on my part. I've not read them yet. The two letters that were ordered by the judge on Friday. If you were here with me or if you caught my recap, you did see that the judge ordered these both sides to give a letter proposal of sorts, kind of saying what they wanted or what they believed was appropriate types of communications for Diddy to be having, whether it be in the jail, outside the jail, etc. And they were supposed to be balancing his First Amendment rights to freedom of speech and assembly and association and all of that with the diminished rights that he has because he's incarcerated and with the rights of the public and the people and the safety of others, et cetera, et cetera. Okay. So that's what these two letters are supposed to be. But before we read these letters, I want to bring to your attention something that happened. I mean, I have been refreshing this docket all day, even as recently as 12 noon. I was refreshing, no, nothing. 12:07, no, nothing. 12:08, no, nothing. And then I'm like, let me go check our good friend over here at Inner City Press because, you know, Matthew Russell Lee, American hero, is always on the case. So somebody, it was Lindsay, I don't know. Yeah, Lindsay, surprise witness. Can someone please page surprise witness? And sure enough, Damian Williams, that's the U.S. attorney in the Southern District of New York, he announced today, just before these filings were due, that he's resigning as the U.S. attorney for the Southern District of New York. And Matthew Russell Lee from Inner City Press asks, what'll happen to recent cases? Menendez, Eric Adams, whatever, all these people, and Diddy. And it's like, you know, good question. And then right after that, we do finally get the two filings popping up. So I just want to go over those with y'all. I did make a separate video. I already recorded it, but it's going to come out. If you're watching on YouTube, it's going to come out in the not in the right chronological order because I wanted to come on here and read these to y'all as soon as I could. First of all, to get the news to you as fast as I can, but also have to record some other stuff today. So I'm trying to get it going. That's why I started this early. I bet y'all were surprised, huh? I'm usually not early. Sorry. I mean, it's usually not like fully my fault. Sometimes it kind of is. It's just like, you know, I want to eat something real quick because who knows how long I'm gonna be on here or whatever, you know. So I can take responsibility. Okay, let me just pull up the filing. I believe the first one we're going to read is document number 85. That's Diddy's. Yes. Okay. Let me pull that up so that y'all can see it. Okay. Document number 85. This is Diddy's letter to the judge as requested. We just discussed. Defendant Sean, this is my first time reading it too. If y'all are just joining, hello, hi, 1200 in the chat. I would really appreciate it if y'all could like the video, make sure that you're subscribed and your notifications are on and all of that. It really does help the channel and helps y'all to get those notifications faster as well. I really don't know. Anything could be anything. Is the algorithm even real? I'm just doing what I think I'm supposed to be doing on here. Okay, so we're reading this letter, document number 85. Defendant Diddy, he was ordered really by the judge to submit this. And of course, his lawyers wrote it. I don't think Diddy sat there and wrote it. He can't even have a pen. But this is what it says. Diddy respectfully submits this letter in response to the court's request, right? Remember, I just told y'all that the court had requested it at the November 22nd hearing for further briefing. That's further, arguments on the writing, like in writing, on the contours of the quote, types of communications. This is what we're looking at. I'm going to highlight it here in yellow. This is what the judge specifically asked, the quotes. He wanted further briefing on the contours of the quote, types of communications that Mr. Combs is able to engage in, consistent with this court's order and Rule 23.1. Okay, so then also, like I just said earlier, he needs to take into consideration the First and Sixth Amendments. Now, we are going to be reading two documents in this live stream, in this podcast episode. Okay, so this is the first document. First document, number 85 on the docket. I started labeling in the thumbnails. If y'all look on the top left corner of the Diddy playlist, these ones, they have a docket number up at the top. And that docket number corresponds to this number I'm highlighting on the screen right here, document 85 up at the top. So when I'm talking about document 85, this is how we'll refer to it, just to make it easier, so that we can all, keep track and stuff. That makes it easier for me anyway. Okay. So it's a letter and it's coming from Diddy, but the other letter we're going to read, the other document we're going to read is also a letter, and that one's going to be coming from the government. So we're going to hear both sides of the argument in this one video today. Okay. Just to prepare y'all. So right now we're reading from Diddy's side. Okay. For months and months, government agents, plaintiffs' attorneys, and others with questionable motives have been polluting the airwaves with false and outrageous claims about Sean P. Diddy Puff Daddy Combs. Okay, that's the first opening sentence of the first paragraph. Look, listen, Mark Agnifilo and them are earning their money over there at Agnifilo and whoever, Jones or whatever. Okay, it goes on. This nonstop drumbeat of negative publicity has destroyed Diddy's reputation and will make it virtually impossible for him to receive a fair trial. Mr. Combs is not required to sit idly by and acquiesce to all of this, okay, is not required, okay? So he's opening out strong, I think, like I said, earning their paycheck over there. And he's saying statements which I also believe are true. Even if you're, charged with a crime, and even if there's evidence, until you're like proven guilty by a fair trial, then you have the right to do a lot of this stuff. Even after you're proven guilty, you still have First Amendment rights, right? So they're not wrong, but let's see where they go with it. It goes on. He has a right to a fair trial and a constitutional right to speak out on his own behalf. The government's arguments that asking his children to post birthday wishes on Instagram and that he is not entitled to publicly express his opinion that the prosecution is racially motivated are quite simply an unconstitutional effort to silence him. Okay, so I'm saying it's Mark Agnifilo. I don't actually know who wrote this letter. I guess we can scroll and see who signed it. Alexandra. Okay, this is Alexandra Shapiro. I may slip and say Mark Agnifilo because I'm just used to saying that. I realize I have a habit of doing that. But this particular letter is written, has been signed and submitted by Alexandra Shapiro, who I believe also is working at Agnifilo's firm. Let me just, yeah. No. Okay, she has her own law firm. I'm glad I checked that. Okay. So this is being submitted by Alexandra Shapiro. I will do my best to not have slip ups and say Agnifilo. I always say that though. I realize it's a habit I need to break. Okay. So Alexandra Shapiro, Diddy's lawyer, is making two major, giving two examples here of two things that she takes issue with. It's that Diddy has the right to a fair trial and a right to speak on his own behalf. Okay. The government's arguments that asking his children to post birthday wishes on Instagram. Okay. That's one thing, right? They're taking issue with the government's arguments about how the feds characterized the birthday post, right? Because if you remember, the government argued that Diddy was trying to manipulate the jury, which is a way of obstructing the trial. Okay, obstruction. And that's one of the reasons they want to keep him in. So the government is saying, Diddy said, I don't care. It's my birthday. That's showing you he's not going to follow the rules and all of that, right? Well, now over here you have Diddy's side saying the government is out of control and incorrect with what they're trying to characterize that birthday message, birthday posting thing as. That's the first thing, right? And then the other thing that Alexander Shapiro brings up is that Diddy is entitled to express his opinion that the prosecutors are racially motivated, which is also that I will say is a true statement. Diddy is allowed to express his opinion that the prosecution is racially motivated. Now, does that mean we have to agree with it? Of course not. Many people would not. Many people probably would agree with that. And so, yes, everyone can express their opinion, including Diddy. Okay. So they're basically just arguing like, okay, the government is spinning things out of control and trying to silence Diddy. They go on the next paragraph and it says, Mr. Combs, quote, sought only to stop a wave of publicity he perceived as prejudicing potential jurors and injuring his reputation in the community. So they're citing case law. They're citing another precedential case that fits so exactly here, right? They're saying this is exactly what Diddy was trying to do. Diddy's communications directed at the public are protected speech under the First Amendment and cannot justify denying bail. And it can also not justify preventing him from engaging in constitutionally protected public relations efforts. Okay, so they're telling us in this part of the legal paper, memo, briefing, whatever, brief, is called the roadmap. They just told you pretty much where you're going to be taken, where we're going to go on this 8-page journey. Okay, the roadmap is, Your Honor, you asked us just 3 short days ago to present to you what types of communications Diddy is allowed to have and make in the world, okay? We are here to tell you what we are going to argue here is that he has the First Amendment right to engage in public relations efforts. Now, specifically, what does that mean? I don't know. We're going to have to keep reading the rest of the filing, okay? But that's where we're going here, all right? This is where we are headed. His communications directed at the public are protected speech. So he's allowed to speak. And this is something that I've had to think about in my own litigation, right? It's like, I don't ever want to have somebody telling me, oh, you can't talk while the litigation's going on or whatever, right? Because I know that I have a First Amendment right to speak about whatever I want to speak about. Now, has my speech been chilled? Yes, absolutely. It absolutely has. That's what happens when people lie under penalty of perjury and stuff. But on the other side, not me. But you have the right to speak to the public. It's a First Amendment right. Okay. Now, they're also going to be taking us down the path of constitutionally protected public relations efforts. So not just speaking on your behalf, but he's going to argue that Diddy has a constitutional right to put together and spin together a PR spin on his own behalf. Now, he may have some strong points. I don't want to jump the gun and act like, we'll see. We'll see. Okay. So then Alexandra Shapiro goes on. She says, so long as they comport with the carefully tailored legal limits imposed by the controlling authorities as described below. Okay. So largely and broadly, according to Diddy, his side of things, he has the right to pretty much speak about anything he wants, except. And this part where except is going to be the rest of the letter. Okay. Under the following conditions, if these are in place, then Diddy otherwise can speak. Okay. So let's see what they're going to propose. And this is Diddy's side. I venture to wager once we get to the government side, it's going to look a little bit different. Some parts probably will look maybe similar, but we'll see. Okay. So Roman numeral 1 up here says, Mr. Combs' communications regarding potential public statements and social media posts constitute speech protected by the First Amendment. Okay. So the first thing we're going to talk about in Diddy's side of things is going to be potentially public statements and his social media posts, including, I'm assuming they're going to get to that birthday post. A, the most demanding scrutiny applies when deciding the issue. Okay, so what level of scrutiny does the judge have to apply, and that's just one of these legal elements. Okay, so it's the most demanding. And they're citing again, I think this is the second time Shapiro cites this Trump case. In United States versus Trump, the DC Circuit assumed without deciding that the most demanding scrutiny applies to pretrial speech restrictions on criminal defendants. Okay. So they're walking us back with what happened in this Trump case, which I don't really know what happened in the Trump case, but it doesn't exactly matter. All we need to know is what they're telling us in the one sentence. Okay. So in this case with United States versus Trump, the DC federal court, quote, assumed without deciding that the most demanding scrutiny applies to pretrial speech restrictions. That is someone's speech who is being accused of a crime, but the trial hasn't happened yet. And so any law or any rule or any restriction or any prohibition on speech that applies in this situation, right? Like pretrial, criminal defendant, and all of that. Any rule there, it needs to be reviewed by a judge with a lot of suspicion. The judge needs to go into that like, I don't know, y'all. We really need to let these people speak. There's supposed to be a bias toward it even. You know what I mean? The strict scrutiny. Okay. Only a significant and imminent threat to the administration of criminal justice would support restricting a defendant's speech. So only what do you have to have? If you don't have it, you cannot stop Diddy from posting on social media. A significant and imminent threat to the administration of criminal justice. And so then, I mean, the question just becomes, I guess, a gut check. What do y'all think? Do you think that Diddy being able to post on social media and make statements to the public is a, quote, significant and imminent threat to the administration of criminal justice? Because that's what it's going to come down to, the judge having to decide. That is what we are deciding on right here. That's what we're being told. The court considered in that case, but rejected application of the less exacting. Okay, so in this Trump case, which was just last year, 2023, in the Trump case, the judge had the opportunity to make it an easier standard on this, like letting, because in the Trump case, if y'all remember, it came down to, can Trump tweet about this? Because similar questions were being asked. I didn't follow that case at all, much less as closely as I followed this one. But they are citing to an issue where Trump was wanting to tweet. He was wanting to tweet and he was wanting to post on social media, and they wanted a gag order to stop him from being able to do it. And they argued that he was a danger, that his tweets caused the danger that they were there about that day or whatever, right? And so in that case, the judge decided, no, I don't know what the judge decided, but in deciding that case, the judge considered this as a factor, which is, was Trump's speech a significant and imminent threat to the administration of criminal justice? That's the question that the judge was trying to get to. And was saying only that could actually make us restrict Donald Trump's speech. And so here we are today. They're using that decision in Diddy's case. And they're saying, well, look, if you couldn't restrict Donald Trump's speech, then you can't restrict Diddy's either under the same principles. Diddy doesn't pose a threat just because he has a happy birthday message on his Instagram. The court even considered making it a lower standard in the Trump case, but declined to do that. Okay, so they just kind of go on a little bit more about the constitutional claims. Diddy, of course, as we know, is a criminal defendant and is, quote, presumed to be innocent. He has a greater constitutional claim than the other participants in the trial, and that is true because he is the one who actually stands to lose his freedom from their participation in this trial, right? So far, I mean, we have yet to see the unindicted co-conspirators, although we have now heard rumblings and references to them in open court. Who knows who's a co-conspirator, alleged or whatever, right? So in this case, right now, the only person who's been charged publicly is Diddy. So The lawyers are arguing and reminding the judge that Diddy, because he's the only one who stands to lose his freedom from this trial right now, he has the most protections here. Okay. The court has to look at this with a very high level of suspicion. Any way they're going to take away Diddy's speech is very highly protected. That was basically the point of subsection A that we just went through. Okay. For those reasons that were described, right? The Constitution and all that. B, the government's burden of proof and otherwise is very high. The Second Circuit, which is another district federal court, has held that per se, wait, is the Second Circuit? No, it's the Ninth Circuit, right? Or is the Ninth on the west? SDNY, what circuit is that in? The Second Circuit has held that per se prescriptions of certain types of speech, prescription means prohibitions, like you can't do it. So like to come out and just say certain types of speech, you just prohibited. Like you can't post anything on social media, right? In the trial context are overbroad and they violate the First Amendment. So they're just citing another court precedent that has said that if you just like give a blanket category and say Diddy can't post X on social media, that is a violation of the First Amendment. So this is again Diddy's side. This is Diddy's argument. We're going to hear what the government has to say after this letter that we're reading right now. But Diddy's side, Alexandra Shapiro, goes on to say, thus, when enforcing rules such as Local Criminal Rule 23.1, which is the one that the judge has to enforce here, the court must examine the specific speech, okay? Specific speech in light of the record evidence to determine if it risks undermining a fair trial. Okay, I'd like to see what she has to say further. She goes on, the Local Criminal Rule, that's 23.1D's general categories of presumptively prejudicial speech are not dispositive of the question. Okay, so just the list that they got listed up there on the statute, it doesn't answer the question. So we have to keep digging to find the answer to the question that we need the answer to today. She says, regardless, as explained at the November 22nd hearing and further in this paper and my other filings or whatever, Diddy's communications at issue do not violate the rule. Okay, so now she's going to argue what the judge asked her. Is it allowed? Am I allowed to let Diddy run around tweeting this stuff? Even I don't care. It's my birthday and all that. She's going to get into her arguments here. And Diddy's side obviously is arguing, yes, he has the right to do this. Because why? Because he's already done it. So they better argue that he has the right to do it because otherwise he might be in trouble. But he also might have the right to do it. You know, we'll have to see what's argued and everything. The party seeking to justify a speech restriction. So in this case, that's the feds that are looking for some type of action to be taken against Diddy for directing his son or his family, his family member to post on his behalf. So the government in this case is the party seeking the feds. They're the party seeking to justify a speech restriction. They're trying to restrict Diddy's speech, so they have to justify it. That's what is being told to us here. Quote, the heavy burden of demonstrating before the trial that without prior restraint, a fair trial will be denied. Will be, not might be, not could be, not is likely to be, will be. Okay, that is very strict language. So the government today has to prove to the judge with these writings that without completely gag ordering Diddy, a fair trial will be denied. And with the evidence that the government has given up so far, I'm not sure they're going to be able to do that because it's got to be like beyond any doubt, will be denied. The record must show the specific, quote, words. Oh, excuse me. Okay. The record must show the specific, quote, words have an extraordinary power to undermine or destroy. Okay, so the words that Diddy wants to speak, and the government has to prove this, have a, quote, extraordinary power to undermine or destroy the efficacy of the criminal justice system. It has to have the power to destroy the whole criminal justice system. Okay, that is a pretty high bar. The government must establish, quote, the imminence and the magnitude, as well as the high likelihood of harm to the court's core duty to ensure the fair and orderly conduct. So that they're just saying this is an extremely high bar, and it is. I'm telling you, it does. Okay. All right. So then it tells you the factors that the court has to consider. And then they move on to their next section, which is the speech at issue, Diddy's birthday messages and the other things they've been citing, does not risk undermining a fair trial. So even if all this other stuff, Your Honor, it doesn't risk undermining a fair trial. The government cited examples of Diddy's speech do not even come close to the order of magnitude that's necessary, what we just read, right? That whole Trump thing. The government argues that Diddy's kids' social media posts showing them gathered to celebrate his birthday evidence obstruction. And they do, right? The government did argue that this social media post was obstruction. They did argue that to spin the narrative. Remember the PR campaign or whatever, public relations campaign, or I don't remember the exact term, but y'all know what I'm talking about. So the government argued that, right, the social media post was an attempt to obstruct the trial and to violate the gag order. The government did argue that. The government further argues that statements that Diddy is a, quote, revolutionary and that the prosecution is racist could be obstructive. Now, I think that these were previously redacted allegations, but then they spoke them in open court, and so now they have become public. So the government argues that Diddy's statements about being a revolutionary and that the prosecution is racist could be obstructive. The government argued that. While the government conceded that a PR campaign or a marketing strategy isn't against the rules, it claims that Diddy's speech is punishable here because Diddy made comments such as wanting to reach for this jury. I just need one. And this is pretty bad. I think this is actually very bad. In my opinion, I'm not the judge. We'll see what the judge says, but this is another previously redacted quote that came out in open court. And it was Diddy being quoted saying, I want to reach this jury. I just need one, saying I need to reach a juror to impact their opinion. It does feel like, at the very least, to me, in my opinion, it feels like a step away from jury tampering or something. In other words, the government argues it is Diddy's stated intent that he wants to influence the jury. That's problematic. Diddy's lawyer says these examples, though, do not even remotely implicate the types of possibly prejudicial speech that courts have previously considered. Okay, so they're arguing and they're saying, Diddy's side is saying, look, Your Honor, Diddy doing a birthday post is not a reason to restrict somebody's speech. Now, I do find them facing an uphill battle, Diddy's side, because Diddy specifically begged and pleaded for the court to issue a gag order. And the gag order was issued on October 25th, 2024. Now, by October 27th, Diddy was kind of orchestrating stuff to be posted on social media, and Diddy did agree that he would not make statements publicly. So maybe I'm mistaken. I am doing this live, so maybe I need to go back and check, but that's how I remember it. So that if that's correct, if my memory serves correct, then that's going to be an uphill battle here, because now they're having to write a whole 8-page long thing about how Diddy has a right to do all of this stuff, and it's like, well, then why did y'all agree to a gag order? Literally exactly 30 days ago. Sorry, 31, a month ago. Today's November 25th. The gag order came in effect October 25th. Okay. The speech doesn't target the correct witnesses. The type of things that Diddy is saying and the type of things that the government is accusing Diddy of doing, his side is arguing it just doesn't rise to the legal level. So to reach obstruction. He does have a free speech right to want, his reputation out in the world to be better. I don't know how strong this argument is. I'm just telling y'all what they're arguing. Okay. So then they start going ahead and addressing the birthday social media post, which is, the one I'm really the most curious about. As for Mr. Combs's children's birthday wishes, that message was entirely innocuous, and they do have a footnote down here. A separate right is also implicated by the birthday posts, for a parent's interest in maintaining a relationship with his or her child is protected. Oh, girl, please. This is a stretch. Y'all should have backspaced that. I'm sorry. Y'all know. I'm sorry, no. They should have backspaced that. They're trying to say he has a right. He has a due process right to maintain a relationship with his children, which requires him getting them all gathered together around the cake to post on social media about his birthday. Please. Y'all should have backspaced that. I'm sorry. That's my opinion. Okay. So as for Mr. Combs' birthday wishes, those messages were entirely, or excuse me, that message was entirely innocuous. It says it could not possibly produce an interference that is material. Okay. So this is the threshold level. This is what they would have to prove, meaning the government would have to prove that he materially interfered with the trial by that having that birthday message. But Diddy's side is arguing, please, they don't even come close to that. It wasn't likely to influence the jury. Now the government's going to come back and say it doesn't matter if it was likely to influence the jury or not. He wanted to influence the jury, and for that reason we have to keep him in jail, because once he's not in jail, he's really going to be trying to influence. That's going to be the government's argument, I'm assuming. Okay, the next segment that they argue is that there are less restrictive alternatives. Like they could just restrict just certain things of Diddy, of his speech, right? They could have not have outright blanket prohibitions on Diddy being able to speak, which again, why did they agree to a gag order is my question. They go on then to argue in section E that the government's stated rule is overly broad. The government's interpretation of the rule is incorrect and inaccurate. They go on in another section to say that Diddy's conduct is also protected by the Sixth Amendment, which is the amendment of the United States Constitution that gives you the right to counsel and to meaningfully participate in your own trial, in your own defense. So first they were talking about the First Amendment. That's what we just got through talking about. Freedom of speech, freedom of defending yourself in the court of public opinion and against perceived discrimination, tyranny. That's why they had to, cite the race issue, because he has a First Amendment right to speak out about his perceived injustices. And he does. I'm in agreement. I agree. I will not be disagreeing. But now they're going to move on to a different section where it says that Diddy's rights are also protected, not only by the First Amendment, but also by the Sixth Amendment. As outlined in his reply brief, the other communications cited by the government reflect Diddy's efforts to investigate and prepare for his defense, including with counsel's participation, nothing more. Okay. So y'all may remember, you may not, but when the government was making their arguments trying to keep Diddy in jail, they were arguing that Diddy was sending witness tampering texts. He was tampering with the witnesses. He was paying people off. He was communicating with people for the first time in a year and all of that, right? Well, also the notebooks with the strategies and the to-do lists of paralegals and things like that. But Shapiro, Diddy's lawyer on this side, is saying, okay, but Your Honor, if you look at all of the stuff that they submitted, really it has one thing in common, and that is Diddy is actively participating in his defense. He is trying. Everything you look at, everything they pointed to, all has to do with him talking about the trial, which is an argument, but there's other ways you could characterize it as well, I'll say. His intent in requesting contacts with potential witnesses, for example, is clear from the record. I'm telling you to hook up with my lawyer because that's not part of our job. I'm not obstructing no laws, nothing. The statements cited by the government evidence neither an obstructive intent nor actual obstruction. Okay. So the government is arguing he has an obstructive intent, and Diddy's arguing no, I don't. So that's kind of where we're left with. So to be clear, if released, Diddy will accept any condition that instructs him to avoid all contacts with an alleged victim and with a potential witness. Okay, so they talked about that before. They're arguing Diddy has a right to do this. He has rights. He has the right to talk to witnesses. He has the right to talk to victims. But Diddy, if you let him out, he won't even do that, even though he has a right to do it. Despite having a constitutional right at the end of the day to assist his lawyers in getting witnesses, Diddy will avoid all contact, directly and indirectly, other than through lawyers, with any people who may be a victim or a witness in the investigation or prosecution. While detained, however, and in the absence of such condition, the status quo remains that Diddy has a constitutional right. Okay, all right, cool, all right. So now what we're getting is Diddy's lawyers, again, this isn't the first time they've done this. They did it in the previous way that we argued. That we read, they argued it. They're trying to leverage. They're trying to say, look, if you leave him in jail, I can't make any promises because he has the right to talk to these people if he wants to. But if you let him out of jail, he will voluntarily give up that First Amendment right. But no, Your Honor, if he's in jail, he has a First Amendment right to do it and you can't stop him. Wow. Imposing any limitation on his rights while he is detained will significantly hamper his ability to assist his defense. So, Sixth Amendment right. Well, look, listen, y'all, I can't say it's the worst arguments I've heard. However, I am always feeling that way until I read the other side. So let me pull up the government's. I shouldn't call it a response because it's not a response. They both just submitted their own briefs. I'm just pulling up the document. We're going to move on to document number 86. Okay. Okay, here it is right here. This one is, like I said, from the government side. The government respectfully submits this in in further opposition to Diddy's renewed application for bail. So we are opposing Diddy getting out on bail again. We have come to you yet again, Your Honor. You got to keep him locked up. Okay, at the hearing, the court requested that the parties address whether the defendant's conduct constituted obstruction. So you see how they already are kind of framing it even a little bit differently, right? They're kind of, even how they interpreted the judge's question is different. Now, I will say, Diddy's side did include quotes. I don't know. I wasn't in there and I don't have a transcript, so I don't know. They could have just thrown anything in the quotes, but I don't know what's closer. Constituted for purposes of the Bail Reform Act. In addition, the court ordered the parties to address whether the defendant's conduct violated the court's. Okay, so this, yeah, they did address it. Address whether the defendant's conduct violated the court's gag order. Okay, that's what I keep asking. Why on earth does the judge want, why on earth would Diddy have agreed to a gag order if now all of a sudden he has to come out and say, I have a First Amendment right to do that? The defendant would properly be able to engage on the perspective. And what communications Diddy would be properly able to engage in on a prospective basis. So looking forward, what types of communications would be proper? For the reasons set forth below, Diddy's conduct, both past and present, constitutes obstruction. And his recent efforts to influence the jury pool, ooh, they're digging in. They're not persuaded by Shapiro and them, I can tell you that. His recent efforts to influence the jury pool are in violation also of Local Criminal Rule 23.1 and in contempt of the very order incorporating that rule that this defendant demanded. You remember that, Your Honor? Diddy asked for the gag order. Not only did he agree to it, he asked for it. His argument that any of this conduct is protected by the First Amendment is baseless, the government argues. Now, if y'all remember, we were just now reading Diddy's side, and I was like, oh, yeah, these are strong arguments. Well, that's why you got to wait till you hear every side. Because this seems strong too. I'm like, oh man, they seem confident. Let's see what they're going to say. Moreover, as detailed in prior hearings and briefly addressed below, Diddy's history of obstructive conduct is part and parcel to his decades-long pattern of violence, which must be considered along with his obstructive content in this current case to fully assess his dangerousness under the Bail Reform Act. A holistic view of his obstructive conduct and his violent conduct, if you look at it all together, Your Honor, conduct that is still happening presently, it makes it pretty clear there's no way to rebut the applicable presumption of detention. Remember, he's presumed to have to be detained because of the Bail Reform Act. It says that you have to presume him to be detained because he is alleged to be have been participating in ST ficking, right? So that's automatic presumption. You gotta stay locked up, right? So the government's saying, look, Your Honor, take a full view, holistic view of his whole entire history in the past, what he's doing in the jail, the present, what you've seen in this case. You got to keep him locked up. The presumption was there for a reason. That's their argument. The bail package presented by Diddy does not come close to ensuring the safety of the community, including from his ongoing efforts to obstruct the case, nor does it adequately protect from the risk of flight. For all of these reasons, his renewed application for bail must be denied. His conduct constitutes obstruction of justice and poses a danger to the community. First, they go ahead and they're going to do the obstruction argument. We've heard this a few times, so I'm not going to read this word for word, but the court did ask the parties to address the definition of obstruction in the bail context. So the judge asked them, what is obstruction in the context of getting out on bail? Under which obstruction of justice has been a traditional ground for pretrial detention by the courts. And this is that LaFontaine case he did ask them to address. The Bail Reform Act does not define obstruction of justice. District courts have interpreted obstruction in the pretrial detention context broadly. Okay. So what is obstruction? They apply it loosely. It's not very, very specific. So a lot of things could be obstruction, is what the government is arguing here. So they're saying you interpret it broadly, which is in stark exact contrast to what Diddy is arguing, right? He's arguing he has a First Amendment right to some of this type of speech that they're calling obstruction. So they're saying when you're defining obstruction, when you're thinking of of obstruction, Your Honor, you got to think of it broadly and loosely. It could be anything. Here's Diddy over here. No, whenever you're trying to take away somebody's rights to free speech, you got to look at it narrowly and specifically. So out of the gate, they're very much on the different sides. Many defendants' obstructive acts discussed herein easily fall within that broad categorization. Okay, so many of Diddy's acts that we're going to talk about easily falls into the categorization of calling it obstruction. Importantly, obstructive behavior supporting pretrial detention doesn't have to rise to the level of criminal conduct. So he doesn't have to actually be committing a crime. The government says we don't have to prove he's committing a crime. All we have to do is show obstructive conduct. And I didn't know that. That might help them here. Finding that they're citing case law here, finding that the defendant in that case threat to a family member, which resulted in a revocation of his bail, constituted obstruction. Okay. So they're citing a case where somebody threatening a family member was considered to be obstructing justice, and he was held on detention prior to trial. Another case they cite, they're saying it was the preponderance of the evidence standard, finding the defendant posed a risk of future obstruction because he had violated orders of another court. Okay, so here's another example that they're giving where in a previous case, somebody violated orders that another court gave before, and that led the judge to think that there was a possibility of obstruction. So he was held in pretrial detention, or she. And in cases in which obstruction is part of the charged offense conduct, okay, so they're differentiating this case even more. They're saying, Your Honor, obstruction is one of the freaking crimes that we are investigating him for. One of the crimes is obstruction. So in cases like that, courts have detained on the basis of risk of future obstruction. Okay, so they have done this in the past as well. They include another example where a defendant was charged with conspiracy to suborn perjury. So that's like conspiracy to make someone do perjury. Related to other counts in the indictment, the court found that strict pretrial supervision and electronic monitoring would provide little protection against future obstructive conduct. Okay, so they're just citing some case law. Here, they say, Diddy's actions fall easily within this definition of obstruction. Indeed, there is significant evidence that Diddy has engaged in multiple acts of obstruction during the time period relevant to the charged offenses. So not only then, but he poses a serious risk of continued obstruction. As set forth below, these acts include multiple acts he took in an effort to stave off the instant criminal charges. So in an effort to stave off, to avoid, to postpone these criminal charges that we are trying to put on him right now, he already tried to obstruct, as well as acts he continued to undertake even after the indictment was returned in order to dissipate the potential evidence against him. It says evidence from the charged period is consistent with his decades-long pattern of obstruction, which the government continues to investigate. So they're still investigating it. For instance, in Diddy's prior 2001 state criminal trial, in which he was acquitted in connection with New York City nightclub shooting, that's the Shine situation, Diddy's then driver testified that Diddy attempted to bribe him $50,000. The racketeering conspiracy offense at count 1 alleges acts of obstruction as set forth in the indictment. In 2016, he bribed security officers with $100,000 in cash to destroy evidence of a brutal assault on a female victim, victim 1, while they were at a Los Angeles hotel for a freak off. In so doing, the defendant relied on intermediaries to reach out to the security staff and to help carry out the cover-up. This act is alleged as part of the bribery racketeering conspiracy predicate. After the victim 1, filed a civil lawsuit in 2023 alleging, among other things, that her participation in freak-offs was not consensual, Diddy made multiple efforts to interfere with victims and witnesses by feeding those individuals false narratives regarding Diddy's criminal conduct. For instance, Diddy caused intermediaries, right, his flying monkeys, his lackeys, former and current security staff, I think that might be the co-conspirators they let slip out at the trial. If you missed that, go watch my most recent couple videos, the live and the video. For instance, Diddy caused intermediaries, former and current security staff, to repeatedly call a former employee who had witnessed firsthand Diddy's abuse of presumably Cassie. The intermediaries told the employee in sum and substance that what she had observed was a normal relationship. Okay, so Diddy apparently, according to the government, I don't know if we've seen this before exactly alleged as it is being alleged here. They're saying Diddy sent his security staff to repeatedly call somebody who was going to maybe be a witness for Cassie and to tell that person this was a normal relationship. They go on to say around the same time, as was highlighted at a prior hearing, the defendant recorded 2 phone calls. So Diddy recorded 2 phone calls with a different victim. This is victim 2, in which the defendants attempted, wait, hold on, attempted, in which the defendant attempted to feed victim 2. Okay. So around the same time, as highlighted at the hearing Friday, Diddy recorded 2 phone calls with victim 2 in which Diddy attempted to feed victim 2 a false narrative regarding victim 2. I think that was a he, his involvement in freak offs, namely that they were consensual. Diddy has evidently deleted messages between himself and key witnesses, including a grand jury witness and victim 2 in this criminal case. One of these witnesses, witness 1, a male commercial S worker who participated in freak offs and received a grand jury subpoena during the investigation. Okay, so witness 1 is a male commercial S worker. I don't know if we knew that before. Who participated in freak offs? Received a grand jury subpoena during the investigation. After defense counsel represented unequivocally, so after Mark Agnifilo and them said at the prior bail hearing before Judge Carter that Diddy would not reach out to grand jury witnesses, it became clear that actually he had done just that. Phone records and electronic evidence shows that Diddy did contact witness 1 repeatedly leading up to and after his appearance in the grand jury. Okay, so this is important because Agnifilo and them had said Diddy stopped communicating with this witness 1 immediately once he realized that he had been summoned to the grand jury. But the government is saying, nope. He also talked to him after, and this is a commercial S worker. And then the defendant apparently deleted the messages from his phone. Okay, so this is a big deal. There were further communications. There were text messages through this entire period, including through August 2024, and they were deleted. While in pretrial detention, he's been using unauthorized means of communication, with which we have discussed. This is the access code numbers from the PAC numbers from the other inmates he's paying for. Contact Me ASAP accounts, which were allegedly apparently unauthorized. And then Mark Agnifilo and them had to concede that on record. The barriers to monitoring Diddy have real consequences, given that Diddy's extensive efforts to taint the jury pool from the prison, even in the communications. Even after Diddy's lawyers told us that the defendant stopped using, oh my God, y'all. Breaking. Do y'all remember Mark Agnifilo getting red in the face? I can only presume because there's no cameras in the courtroom, but do y'all remember Agnifilo saying in writing at least one time, maybe more than one time, that Diddy has stopped using Contact Me ASAP? And Diddy obeys us. My client obeys me or whatever, right? Remember that whole thing just happened 3 days ago? Well, even after defense counsel, that's Agnifilo and them, represented that Diddy had stopped using Contact Me ASAP, he has continued to use Contact Me ASAP. Oh my God, y'all. As recently as freaking yesterday, November 24th. At least one other inmate sending messages to a family member as recently as yesterday. Yep, and they quoted Mark Agnifilo right here, quote, with respect to Contact Me ASAP, he stopped using it November 16th. That's bad. That's bad. He didn't even have to offer that up, and here he is offering it up. While at the MDC, Diddy has instructed family members and third parties to contact multiple potential victims and witnesses. See, he might have a First Amendment right to contact somebody, but using an intermediary, I think, does actually muddy the waters a little bit. The government says the defendant, that's Diddy, has provided these instructions to others by using unauthorized means of communication, which, as described above, are difficult to monitor. And often he uses coded language. Wee woo, wee woo. Number two, interesting thing. The potential victims and witnesses that Diddy has instructed others to contact include former romantic partners, former employees, most of whom have experienced or witnessed Diddy perpetrate significant violence. At the hearing on Friday, Diddy's lawyers argued these contacts went through his attorneys. However, this is just simply not the case. They're saying, no, Your Honor. They're lying. Diddy and his lawyer are lying to you, Your Honor. They told you Friday the contacts all went through attorneys, but that's just not the case. For example, they're giving examples, y'all. Whew. For example, Diddy asked a family member to call victim 2. Separately, Diddy had a family member three-way dial a co-conspirator. Oh my God. And the defendant and co-conspirator used coded language, y'all, discussing a certain blank who has to blank now and blank. Discussing a certain beep who has to beep now and beep, 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 beep. Then they quote Agnifilo down here, footnote 3. Defense counsel stated during September 18th. So Mark Agnifilo stated during the September 18th bail hearing that Diddy did not reach out to grand jury witnesses. Quote, I dispute that wholeheartedly. He didn't do it and he wouldn't do it. And he wouldn't do it because he has the sense not to do it. And he wouldn't do it because we wouldn't let him do it, you know? Then, at this last Friday bail hearing, the lawyer conceded about the deleted messages. Quote, I don't know the factual answer. In response to the court's question regarding the circumstances about the communications, he just don't know. Mark Agnifilo didn't know. Okay, now this is crazy. Look at this sentence right here. While at the MDC, Diddy orchestrated a social media campaign around his birthday for the express purpose of influencing the jury in this criminal case. Okay, so it was not, the purpose was not permissible under free speech, Your Honor. And the multiple calls leading up to the birthday post. Okay, so we're getting a little more context about this birthday post. Multiple calls leading up to the birthday post, all of which occurred on unauthorized communication channels. Diddy meticulously planned out the post. Oh my God, y'all. They are just exposing him out here. Oh my Lord. There was multiple calls leading up to the birthday post, all of which occurred on unauthorized means, which maybe Diddy didn't know that people were going to be able to get his calls that way. He meticulously, quote, meticulously planned out the post. The video depicting 6 of his children singing him happy birthday while speaking to him by phone was initially posted to the children's pages. But Diddy was not satisfied that it would reach the correct demographic. Wow. Wow, that is damning. They initially posted it on their pages. Then Diddy wanted more views. The government's saying. He told a family member that he had been tracking the analytics and directed the family member to post the video to his personal page because his social media followers are blank redacted. Ooh, I'd love to know what Diddy said about his social media followers. In another call the same day, Diddy talked about the reach of this social media post. Okay, so he was asking a question the next day about it. So he's keeping track with the analytics. The government is arguing that this is evidence that Diddy is meticulously orchestrating and planning out, quote, a social media campaign around his birthday for the express purpose of influencing the jury on the criminal case. Okay, so the government goes on. District courts have detained pre-trial defendants on obstruction grounds on less than what Diddy has done, Your Honor. So they cite this case Quack, finding the defendant engaged in obstructive conduct, warranting pre-trial detention when a message posted on his social media account accused prosecutors of bias. Oh my God. So that is exactly what Diddy is doing. Oh, that's bad. Finding risk of future obstructive behavior identifiable. Okay. But however, the defendant encouraged followers to harass victims in the case. So Diddy did not. I was not encouraged to harass. I don't think he encouraged anyone to harass. And in that case, the defendant had previously used burner phones to conceal communications with co-conspirators, which they're trying to argue is basically what he's doing by using these unauthorized means of communication. At the November 22nd hearing, Diddy attempted to distinguish his own obstructive conduct from more violent examples of witness tampering. The distinctions, no, miss me with it. It's unavailing. He's charged with leading and founding a racketeering enterprise that on numerous occasions committed acts of violence, including trafficking, kidnapping, and arson. Some of these acts were done by Diddy, and others were done by intermediaries acting at his direction. Any obstruction or tampering by him must be viewed through the lens of that underlying violent conduct, as well as the lens of his enormous influence and power. Moreover, the Second Circuit has explicitly noted that both violent and nonviolent witness tampering supports detention on the basis of potential obstruction. Okay, so they're saying Diddy might want to make a big deal about throwing the contents of a vase, throwing a this, throwing a doing this, doing a that. But Your Honor, no, I'm just so sorry. Violent or not, obstruction is obstruction. Other courts in this district have rejected arguments like those advanced by Diddy relating to public relations strategies built on discrediting witnesses. Okay. So Diddy did say this, or his lawyers did, that Cassie's credibility is going to end up being the most important issue at trial. So Diddy is allowed to attack her credibility in the media. That's what Diddy's argument is. The government said, no, hold up, swell up. Absolutely not. No, you may not. The judges in this court, in this district, have rejected arguments like that already. It's already been decided. You cannot build a public relations strategy on improperly influencing jurors, nor on discrediting witnesses such as Cassie. In the context of bail revocation, Judge Kaplan found that a similar pattern of obstructive conduct warranted detention in the Sam Bankman-Fried case. Okay, so remember they kept Sam Bankman-Fried locked up? So they're talking about the arguments that were made in that case to keep him locked up. And the government is saying that case is instructive because unlike here, that defendant, Sam Bankman-Fried, was charged with a nonviolent crime. This is a good argument. Specifically, perpetrating a multi-billion-dollar fraud related to his operation of a cryptocurrency company or cryptocurrency companies that he founded and controlled and was initially released on $250 million bond, subject to conditions, including home detention. However, in that case, after Sam Bankman-Fried reached out to a witness on an encrypted messaging service, used a VPN, preventing the government or pretrial services from obtaining evidence on the websites he accessed, and funneled diary entries of a key cooperator to the press, the government moved to revoke bail. And they're saying, look, there was not even any violence there. The court agreed with the government on the basis of the defendant's obstruction, finding that no condition or combination of conditions would assure the safety of the community and the consequences of witness tampering. The court rejected the defendant, that's Sam Bankman-Fried's argument, his alternative proposal, a gag order on communications with the press, finding that it was not a workable solution longer term. So they actually gagged him from making any communications with the press as well. Finally, the government says it cannot be ignored that Diddy's proclivity for obstruction appears to have continued as recently as last week in court, when it appeared that the defendant provided, quote, oh my God, y'all, this is a quote, falsified documents to the court during a hearing. Falsified documents convened to address his accusations of government misconduct. At the November 19th conference, Diddy's lawyers presented the following about the condition of Diddy's legal notepads prior to the notepads being photographed. Okay, so remember all that stuff coming up about legal? Did Diddy have the word legal written across the top of his notepad? Mark Agnifilo presented to the judge a legal pad that said legal on the top, but that's not what the government took pictures of. So they were presenting, according to the government, falsified documents. On top of the legal pad, this is a quote, he's handwritten in blue handwriting the word legal. All these legal pads say legal. All these legal pads say legal. That's what Mark Agnifilo said. That page was in a legal pad, and at the top of the legal pad was marked as legal. Days later, in response to the court's order demanding him to explain himself, he admitted that the word legal was written on the notepads after the notepads were photographed. Now there's a photo of legal pads that was in the materials that the government gave us, whatever it was, earlier this week, that doesn't have legal on it. No, the materials they gave you earlier this week is the exhibits they attached. Like, that's the thing. Like, I'm down, like, to be fair to Diddy's side and stuff, but like, this feels bad faith in my opinion. Materials that the government gave us, whatever it was earlier this week. No, it was exhibits attached that you based entire claims acting like you were trying to get a mistrial based off of it. It has to be the case that as of the day of the search, November 1st of this year, legal wasn't written on every pad. The inference is clear. After the BOP sweep, Diddy wrote legal on top of at least one legal pad to support his argument that the materials in the legal pads were privileged. This continued obstruction, while he had a pending bail motion, no less, should certainly be viewed. Okay, so falsifying evidence. Now they're saying he's falsifying evidence. So the ball's back in the government's court. Because remember, the ball had really gone into Agnifilo's court. He was like, Your Honor, they have our legal notes. And so he was like, oh, you got to destroy them and all that. Well, now the government's like, no, ball's back in our court again. Remember that? Oh, look at this. Oh, that's not his case. Sorry, excuse me. Okay. Then they argue that he's dangerous. He has a significant history of, quote, violence. It must be taken into account when viewing that his activity of obstruction, that he could hurt people. So you don't really need the violence to keep him in jail. But then on top of it, he also has violent proclivities, is what they're saying. His conduct violates local criminal rule. His social media posts violate the rule. Within 2 weeks of the court's order, he instructed family members to create the birthday social media post, directing them to ensure that it's a, quote, I don't know, blank. And then just quote all these quotes. On his birthday, the social media post went live on his children's accounts. As described above, the post depicted 6 of the defendant's children singing happy birthday while speaking to him by phone. His intent couldn't be clearer. He wants to influence the jury pool. Okay, and they're finally saying, look, he does have First Amendment protections and rights to free speech and all of that, but what he's doing is absolutely not granted under the First Amendment. Like, that extra stuff he's doing is just not. That's all I really had for today. Let me get to some of these super chats. Adam, welcome to members. Holly, thank you for the 199 super sticker. Oh my gosh, Sean gave 5 memberships. Thank you, Sean. If you got one from Sean, make sure you shout out to them. Say thank you. Katie did. Thanks so much for the 999 super chat. Goddess of the Galaxy became a member. Silly rabbit, he can't follow jail rules. He obviously don't know how to stay in line in kindergarten, just saying. Exactly. Thank you so much for that $5 super chat, silly rabbit. And I know you've been in there modding. Jonathan Audie. I don't know what Jonathan Audie is or where he is, Edie. Member for 13 months. Shout out to you. The Diddy docket. Yes. Are you the same one from Twitter? Thank you. Your prompt and entertaining reading is appreciated. Thank you so much for the $20 super chat. Wow, that is really appreciated. Thank you. Thank you. Thank you. Thank you. Yeah, well, like I said at the beginning of maybe I didn't. I got to go record some stuff for BJ Investigates, so I do have to run. But that's all I really have for today. In the meantime, facts ain't defamation. Love you, mean it. Bye.